Hello everyone, and welcome to our latest edition of MoFo News, an introduction to our 2025 case law roundup and what may be on the horizon in 2026. You can access our full article on the MoFo Insights page or through the link below.
As predicted, this year has seen major developments in the collective proceedings and litigation funding landscape, notably with the continued expansion of the regime in the Competition Appeal Tribunal and the Civil Justice Council's recommendation that the decision in PACCAR is reversed by legislation. At the same time, the Court of Appeal has clarified how funding agreements can be restructured, easing much of the uncertainty left in PACCAR's wake.
We have also had a number of significant commercial judgments handed down this year. In particular, the courts reaffirmed the high threshold for proving fraud in a dispute concerning the purchase of property in Sloane Square by the Vatican, hailed as the trial of the century.
In the privilege space, the Privy Council has brought an end to the long-standing shareholder rule, meaning companies can no longer assert privilege against their shareholders except in legal proceedings involving shareholders.
The Privy Council also clarified the law of misrepresentation, confirming that claimants need not be consciously aware of a representation to rely on it. The focus is now on the conduct of the party making the representation rather than the claimant's state of mind, a shift that could affect future deceit claims.
Looking ahead, group litigation is likely to remain a key feature of the disputes landscape in 2026, with judgment in the Dieselgate litigation expected in the summer. We're also expecting a clarification from the Supreme Court as to how sanctions laws affect payment obligations under long-standing contracts, particularly the extent to which financial institutions can rely on a reasonable belief defence when withholding payments linked to sanctioned entities.
In arbitration, we'll begin to see the impact of the new Arbitration Act, the first major update to the regime since 1996. The Act introduces streamlined procedures, clearer rules on the law governing arbitration agreements, and stronger court support where needed. It's a timely refresh of a system that has served so well for nearly 30 years and will help to keep London at the forefront of the international arbitration market. And finally, in the commercial court, a new pilot scheme on public access to court documents will begin in January 2026. Key hearing materials will be filed for public inspection, a step towards greater transparency that may also prompt parties to think more carefully about confidentiality and settlement before trial.
For more detail on these developments and what to expect in 2026, you can read our full roundup on MoFo Insights.